Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. On the 17th of March, 2025, the defense filed the defendant's objection to state's motion in limine regarding the admission of certain evidence associated with the 911 call that was placed on November 13th, 2022, just minutes before noon. The defense's objection is basically focusing on the fact that this is hearsay evidence, that Mr. Kohberger will not have the opportunity to confront facts or alleged facts that are presented to the jury in the form of a transcript as he would if this were testimonial, meaning DM gets up on the stand and the defense can then ask questions of DM and cross-examination, or BF gets up on the stand and the same. This is the principal beef that the defense is making, that it violates Mr. Kohberger's constitutional rights to be able to confront evidence that is presented against him. He raises other constitutional grounds. It says here that Mr. Kohberger hereby objects to the state's motion in limine to admit the 911 call and an accompanying transcript. So he wants both to be prevented from coming into the case, from the jury being able to hear, read, and know about this information. Regarding the 911 call, page 2, the defense alleges the state correctly recognized the statements on the 911 call are hearsay. However, the state alleges that statements fall within the excited utterance or present sense impression exceptions to the hearsay rule or are non-testimonial, meaning this is not evidence that must be presented in the form of witness testimony in the courtroom up on the stand where Mr. Kohberger's counsel would have the opportunity to cross-examine that witness. Then, in alleging that this is not excited utterance or present sense impression, the defense then gives legal argument citing to Idaho case law that says what excited utterance is. It must be an occurrence or an event sufficiently startling to render inoperative the normal reflective thought process of an observer. And the statement of the declarant must have been spontaneous reaction to the occurrence or event and not the result of reflective thought. So in other words, this must happen contemporaneously as whatever the triggering event is, the excited utterance that the declarant makes in order to get out of the hearsay exception, to be an exception to hearsay. It's got to happen at the time. In other words, think of it as a person walks by a stove, puts their hand on it, not realizing that it's extremely hot, and then says words, startled, excited utterance about what just happened. Not an hour later or 2 hours later, where things could be changed, where there's been reflective thought that goes into what happened an hour or two later. What the defense is saying here is the 911 call did not come at 4:30 in the morning when DM and BF communicated with each other and ended up in the same bedroom. This 911 call came some 8 hours later. This call came after DM and BF each made calls, corresponded through text and other messaging to family and friends. The call came only after friends arrived, and as to one of the friends, on the next page, this is EA who was on the call. EA does not have firsthand information and is repeating what DM and BF told her, so it's sort of like hearsay upon hearsay. If you would like to review this document, it has been published March 17th. We await the state's reply to this response, which is due on or before the 24th of March. This is Kathy. Thank you for joining us here today.